Good afternoon, everyone. It's great to be here. We have quite a large crowd attending today, and it's a wide range of people attending literally from around the world. We're just going to wait a minute or two while some more people log in. So we will have that usual awkward silence that we're all used to by now at the beginning of webinars and Zoom calls, and then we will start our webinar very shortly. So if you can just hang on for just a few more seconds, and then we will formally begin the presentation. Okay, so thank you, everyone. It's great to be here today. My name is Mark Evans. I'm a partner in the Trademark Practice Group at Smart & Biggar. I'm joined by my partner, Katerina Simberes, and I'll be one of your speakers for today's presentation on Canadian brand protection enforcing trademarks in Canada from oppositions to litigation. Katerina, next slide, please. Before we begin, just a couple of housekeeping matters at the outset. Our presentation will last probably about 45 minutes, and we will have an open Q&A session at the end where we can address more specific questions that you might have. You're also welcome to submit questions at any time, but if you are going to submit questions, please do so by using the Q&A button at the bottom of the screen. Don't type your questions into the chat. Use the Q&A button at the bottom. Also, today's webinar will be recorded, and following the presentation, we will circulate an email to everyone in terms of the presentation, and as well at the end of the webinar there will be a link that will pop up for a survey, and if you would be good enough to complete the survey, that would be quite helpful for us, especially to learn about any future topics that you might be interested in. So with that, let's begin. I expect that most of you are very familiar with our firm. I recognize many of the names of today's registrants, and as I said, it's a large group from around the world. But just a couple of quick words about our firm. As I said, you probably are aware that we are Canada's largest IP firm. We've been around for more than 100 years. We are located across the country. And while we file more than 8,000 patents and trademarks annually, what is of most relevance today is that we've successfully handled many, many litigation matters over the last many years, and certainly many unprecedented trial victories in the last 5 or 10 years in trademark cases. Next slide. And I won't dwell on this, but because of the numerous victories that we've been fortunate to have on behalf of our clients, including in highly important bet the company trademark litigation, we have been repeatedly recognized as Canada's leading trademark and IP litigation firm. Next slide, Katerina.
So the purpose of our webinar today is to share with all of you some effective strategies and best practices in Canada for successful trademark protection. These include, as many of you should know, Canadian opposition proceedings, Canadian trademark litigation proceedings before the courts, and Canadian non-use summary cancellation proceedings, or what we call Section 45 proceedings. So we will cover these types of proceedings with you and how to use them to the brand owner's advantage. So when you're looking at an enforcement strategy, you need to understand, all these for different proceedings well. Oftentimes, we don't handle them in a silo, and oftentimes we end up with a strategy that comprises one or more of these, sometimes even 3 of these at the same time. So we need to know how they play out to best enforce trademarks in Canada. So our first tip today is the importance of a trademark registration. Sounds simple, but it isn't, and it's super important. In Canada, registration affords a monopoly, the trademark's exclusive use across the entire country of Canada. And irrespective of whether or not there is little or lots of use, and irrespective of where in Canada the trademark the registered trademark is being used. So I'll give you a really simple example just to visualize it. I always like this one, but a restaurant by the name of Mambolzuc, for example, that is registered and that has only a location in the French province of Quebec, where I work, has the exclusive rights across Canada, irrespective of the fact that they're only located in the province of Quebec, for example, and can stop an infringer in Vancouver, even if the goodwill of its trademark hasn't extended to Vancouver per se. That is the beauty of a registration. So and on a separate topic, as many of you know, the Canadian Trademarks Office is rather slow in the registration of trademarks. We won't talk about that because everybody always says that. It's a bit boring. But if litigation is contemplated, for example, we just wanted you to know that examination of a trademark application that hasn't been registered can be expedited rather quickly and obtained in a few weeks in certain circumstances, especially if litigation is contemplated, as I said. So here again, other importance of having a registered trademark. Canada has a robust trademark provisions, but only available if you have a registered trademark. In most of the cases, we'll get into more details later, and it's the same for customs recordals and the customs enforcement provisions that you have access to when you have a registered trademark, which is a really relatively easy and effective process, but it requires a registration. Also, easier to litigate when you have a registration. You get some presumptions of ownership and validity, which are really practical. And there's also the limited incontestability. So you can challenge, for example, on the basis of non-distinctiveness, despite the incontestability. So the grounds of, for example, genericness and distinctiveness and descriptiveness do not expire when a registration is 5 years old. And the grounds do fall away when a trademark is more than 5 years old that are based on prior use or making known of one's own trademark, unless the other side can establish that, or you can establish that the other side adopted their trademark with the knowledge of your trademark. So limited incontestability, but still interesting. Mark?
So against that background, let me give you a cautionary tale based on a case that I was actively involved in several years ago. So if you don't have a registered trademark, you can still enforce rights in Canada. Canada recognizes common law rights, so you can bring a passing off action in the absence of a trademark registration. And you can do so even if a party is not operating in Canada based upon a foreign reputation if it spills into Canada. So for example, 90% of the Canadian population lives within 200 miles of the US border. We get bombarded with US media. We of course see US social media, and Canadians travel to the United States all the time. So US brands are extremely well known in Canada. And there are certainly many cases in which US brand owners have been able to successfully stop and enjoin businesses from operating in Canada, even though they don't have a registration in Canada, and even though they don't have operations in Canada. However, that's not always the case, and the slide is reflective of this. Target department stores in 2011 opened dozens of stores in Canada for the first time. It invested $4 billion to set up shop in Canada. It was the largest retail launch in Canadian history. However, Target did not have any trademark registrations in Canada at the time in relation to store services. And our client is the business that was operating the store shown in the image on this slide. Our client was operating under the name Target Apparel. It had about a dozen stores in Canada. And frankly, like Target department stores, it had a facade that was red and white. Target department stores brought an action to enjoin our client before trial on the basis of passing off. However, they were not successful. And the court noted a number of things, whether it was the fact that it wasn't a bullseye, rather it was a maple leaf on the facade, or importantly, and again, this is one of the many factors that applies in relation to a passing off case. is that you need to look at all of the factors, all of the indicia, and our client had posted prominently in its windows and at point of sale, essentially disclaimer notices to the public indicating that they were not associated with Target department stores of the United States, so that consumers would not be confused. We succeeded in successfully defending the injunction application, and then the case eventually settled on confidential terms. But again, I really think that is a cautionary tale, because if there was a trademark registration in place, the results could have been very, very different. Next slide, Ekaterina. And one more. So
this one's actually mine.
Was that yours? Thank you.
Sorry. So turning now to opposition proceedings. We're leaving the litigations for a little bit later. So continuing on the subject of the importance of registered trademarks, another tip that we wanted to share with you today in terms of a strategy is to watch the register and oppose in time. I mean, it seems simple, but in connection with watch searches in place, you should do that. It's better to oppose than to have to expunge later in the federal court. And you should be watching for your most important marks, but you should also be, watching maybe for some particular competitors that are worthwhile watching for. So really important, file the opposition, watch and then file opposition within the deadlines. Oppositions are much less expensive than expungement proceedings after the registration has been granted. And as we said, after the registrant has, the rights to the exclusive use in Canada. Here again, just to let you all know that every trademark application that is approved by an examiner is vulnerable to oppositions being launched. Since 2019, we're seeing a lot more oppositions for, reasons that we've already, that we've heard about. More applications because of Madrid filings from people around the world. Also under the amendments to the Trademarks Act in 2019, the fact that we didn't have to have use in Canada before a trademark is registered. And also the troll filings that were filed before the class fees came into effect. And are currently being published for opposition now. So really important, increased importance, and we'll talk later on about the material dates to oppose, but that's really important, and there are differences between a Canadian, the benchmark deadlines for a Canadian or Madrid application. Mark.
So in relation to opposing applications, there are numerous potential grounds of opposition. And many of these will be well known to you, whether it is confusion with a registered trademark or prior unregistered rights, or that the mark is descriptive, whether geographically or that it's a name, or that the mark is not distinctive. And distinctiveness is an extremely important concept in Canadian trademark law in terms of a trademark designating a single source, or that the mark is just not inherently distinctive. Also for applications filed before the amendment of our Trademarks Act on June 17 of 2019, if there was an incorrect filing basis, you can oppose on that very technical ground. That doesn't exist for applications filed after that date. And the new addition since June of 2019 is the ability to oppose applications on the basis that they were filed on the basis of bad faith. And that is something that sort of existed before, but it is certainly something that is much more important now, especially dealing with trolls. In relation to onus and burdens, there is an initial evidentiary burden on an opponent to make out the grounds that it asserts in its statement of opposition. However, ultimately, the legal burden is on the applicant to prove that its trademark is registrable. And as a result, it is possible to have a situation. This burden is the exact opposite of the burden in infringement proceedings in the federal court. In the federal court, in an infringement case, the burden will be on the plaintiff to establish that confusion is likely, as opposed to in the opposition proceeding, where the burden is on the applicant to establish essentially the confusion is not likely. And so it's, as a result, it is certainly possible, and it has happened, to have a decision of the opposition board rejecting an application as not being registrable due to confusing prior trademark rights, and yet on an infringement litigation involving the very same trademarks, the federal court finds that there is no infringement because the plaintiff did not make out its case. And the opposition board's decision is not considered to be presumptive or determinative in terms of any infringement proceedings in the federal court. Next slide. So in terms of trademark opposition procedures, there are many potential steps. However, most of these are optional. The first steps in the opposition are essentially the pleading stage, the statement of opposition that sets out the legal grounds of the opposition, and then a summary denial by an applicant in their counterstatement. The opponent, if it files evidence, and an opponent doesn't need to file evidence. If it wishes to simply hold up a trademark application, it may wish to not file evidence. It may just wish to oppose. But in a typical case, if an opponent files its affidavit evidence, it could be cross-examined on that affidavit evidence. The next step is for the ability for the applicant to file its evidence, and again, subject to the right to cross-examine the applicant's affiant. There's then the ability to file reply evidence, written arguments, and then an oral hearing. The process is slow in the Trademarks Opposition Board. Frankly, it's slower to get to a decision in an opposition case than it often is in an infringement case in the federal court. It typically takes several years. There is an absolute right to appeal to the federal court. However, there is pending legislation that will make it a requirement to obtain leave to file additional evidence on appeal, which essentially will make it much more important to get the case right at the outset, given that there will likely be a difficulty in successfully filing additional evidence and succeeding on appeal. And frankly, I think it could have a chilling effect on appeals in the future.
So, yeah, it's always best to put your best foot forward, Mark. I mean, I think it's going to become even more important. I agree with you. So in terms of evidence now, different grounds of opposition have different material dates. So fully appreciating the different material dates is important to ensure that you have admissible evidence that fits with your material grounds of opposition. For example, grounds based on entitlement have, material dates at the filing date, many years, sometimes before the opposition, is being filed. So you're stuck with, trying to figure out how do you bring in evidence and investigations by investigators being instructed by counsel to go and find that evidence for us, clients working on it, us working on it, but it makes it, the material dates does make things challenging, and we have to be very conscious of it. On the Trademarks Opposition Board's reluctance oftentimes to give credence to foreign activities or the foreign reputation of marks, really important to be aware of that, and trying to find a way to prove it, not what you want to prove, nonetheless. As for virtual and remote cross-examinations, they are the norm now after the pandemic. That's one benefit from the pandemic, quite frankly. I think our clients are benefiting from it. I think we're benefiting from it, making things less expensive and more cost-effective and time-effective for the lawyers as well. And presently, no cost awards, but we'll talk a little bit later in another slide in terms of impending changes, as Mark has already relayed. Actually, this is the slide. So as we said, currently now, there's no cost awards in opposition proceedings, but there is legislation in place that is going to be coming into force. We think, I spoke to somebody from our firm yesterday, in preparation for this presentation that is in communication with some members of the government, and they're thinking probably by next year. That's the current thing that we've learned. So cost awards to safeguard against abusive practices and increase the efficiency of oppositions. There's going to be fixed amounts that can be cumulative depending on the, for example, the 3 examples they've given us is unnecessary divisional applications, unreasonable behavior, and a successful opposition based on a bad faith ground. It's yet to be finalized, so we're waiting to hear, but the amounts are not very significant as they would be in the federal court, for example. It would be more. Second changes would be on case management to abbreviate the deadlines and vary the manner in which some steps are completed. That's welcome news, I think, to everybody who does oppositions a lot. And confidentiality orders for you to know. Currently, when one files evidence in before the Trademarks Opposition Board or the Trademarks Office, it's the same thing. Any party who requests and wishes to obtain a file wrapper, a complete file wrapper, a copy of the trademark application or Trademark Opposition Board proceeding can obtain it. So we're always faced with, how much evidence do you put in to prove, your grounds of material grounds, knowing that, there is no confidentiality orders available. With the changes probably going to happen next year, it's to prevent the public access to confidential information that's going to be necessary, and we'll be able to caveat things. So that's really practical. And lastly, Mark already talked about it, so I won't talk about the last point, but additional evidence on this being filed only on appeal from a trademark opposition board decision with leave from the court. I can't believe it's still me, Mark. Canadian trademark litigation. I'm just kidding. So now changing topics now, Canadian trademark litigation. We finished oppositions. We get, brand owners looking to enforce their rights in Canada can do so confidently, I think, rather inexpensively and expeditiously. Especially when we compare ourselves to other common law jurisdictions, including our friends south of the border, which offer brand owners a number of tools to obtain relief against infringers and counterfeiters in a cost-effective manner. So we're going to be presenting you a number of reasons, Mark and I, as to why we think Canada is an attractive forum for trademark litigation. And before Mark speaks, because I haven't let him speak. I'm used to it. The causes of action available to brand owners in Canada, they're fulsome. I'm sure a lot of you on the call, we've seen the names, are aware of these, but there's 4 main causes of action. The first is trademark infringement, which Mark has already alluded to. 2 sections of our Trademarks Act that govern this provision. One requires that the mark be virtually identical, and the second looks to statutory factors that should be considered in order to determine whether or not a confusion is likely between 2 trademarks. The second possible cause of action, and these are cumulative as well, and we'll, oftentimes Mark and I, in cases that we've handled together, we've alleged all of them and we've been successful, but passing off is the second one. Passing off is the, in Canada, in our Trademarks Act, we've codified the common law tort of passing off, and it requires similar to other jurisdictions, the proving of a goodwill in a trademark, public deception due to misrepresentation, and damages. And really important here is for passing off, all surrounding circumstances, including, for example, the pricing of products, for example, is relevant to a case of passing off, whereby which it would not be relevant, for example, in a pure trademark infringement matter. Thirdly, we've said dilution just to bring it down, but basically in Canada, depreciation of the value of the goodwill of a trademark is another cause of action that is available. And it's really practical in cases where there might not necessarily be confusion in Canada between 2 trademarks, but when the use of a registered trademark that has significant goodwill brings to mind another mark, so think mental association between 2 marks, and it is used in a manner that likely depreciates the value of the trademark. And there's been some, really good cases. Recently, it's gone up back and forth to the Federal Court and Federal Court of Appeal. And there's some discussion about The federal court having held on the summary judgment motion, I believe the last time I read the case, was that a claim for depreciation of the value is not limited to registered trademarks and minor misspellings thereof. So there's a little bit of a broadening of that, even though the Trademarks Act does mention a registered trademark. So something to keep in mind. Lastly, possibility of filing for expungement or invalidation of a registered trademark. Mark.
Okay. Actually, just before I get to this slide, let me just say in terms of dilution, just picking up on Katerina's point, dilution was essentially an overlooked cause of action in Canada for decades and decades and decades. And then we had an important Supreme Court of Canada decision about 15 years ago. And since then, I haven't looked at the statistics in terms of success on depreciation of goodwill dilution cases, but it has been highly significant. I know initially the feeling was that considerable evidence would need to be provided to establish the necessary factors, but in many, many cases, the court has found depreciation of goodwill or dilution on relatively thin evidence. So it is, I think it's a powerful cause of action.
Yeah, including, Mark, I'm sure you remember the Toys R Us versus Herbs R Us case, where the court found for depreciation, having not found for confusion. So it was really helpful to that entity, Toys R Us, to have that disposition. Go ahead, Mark, on the Canada's federal court.
Yeah, so the vast majority of IP litigation, including trademark litigation in Canada, is conducted in our federal court system. Our federal court is truly an excellent court. It has nationwide jurisdiction. You don't need local counsel. It's bilingual, and it has appointed non-elected, highly experienced and highly capable judges. In fact, in the last 10 or 15 years, the federal court has appointed a number of individuals who are leading IP practitioners. As a result, there really is a high degree of experience and expertise in trademark cases in the federal court. One question that often arises relates to forum shopping, but the federal court, it's important to realize, is not divided into circuits. It's not divided into districts. Rather, all of the judges in the federal court sit across the entire country. So there is no ability to forum shop within the federal court. That said, there are a couple of important points in relation to the federal court's jurisdiction. First of all, the federal court, its jurisdiction is limited to matters of federal legislation, such as the Trademarks Act. However, if matters that don't fall within federal legislation cannot be litigated in the federal court. So, for example, a trade secret case. And it is not like in some jurisdictions that it's enough to have one cause of action that's within the federal court's jurisdiction to then bring in other causes of action that normally wouldn't be permitted. They all have to have jurisdiction within the federal court. So if you're looking at a case that combines trademark infringement and, for example, trade secrets, and you want to litigate them in one court, then you would look at litigating in our provincial court system. And each of our provinces has its own court system. Generally speaking, the provincial court system isn't preferred. They generally have lesser expertise in IP matters, plus their jurisdiction is going to be limited to one province. However, and Ekaterina is going to talk about this in terms of injunctions, and it's difficult to get pretrial injunctive relief in Canada generally. But frankly, in some provincial courts, it can be a little bit easier in some situations to get pretrial injunctive relief in trademark cases. In those cases, where a party receives a demand letter from a brand owner located in one of those provinces where it can be a little bit easier to get pretrial injunctive relief, sometimes a worthwhile strategic move is in fact to bring a declaratory judgment action in the federal court. So the federal court then has jurisdiction over all of the issues, and the federal court, as Ekaterina will talk about, is not generally an easy place to obtain pretrial injunctive relief.
So that's you, Mark.
Was that me? This is me. Okay. So typically, most litigation in the federal court is handled by way of what is called an action. And litigation by way of action is relatively similar to the litigation process in the United States, but there are some differences. First of all, in terms of documentary disclosure, it is not a situation where you provide interrogatories or requests for documents. Rather, there is a positive obligation for each party to disclose all documents that may be relevant to the issues in the litigation. So there's a positive obligation to do that. Second, in terms of the deposition or discovery stage, it's similar to, in the US, Rule 30b-6, insofar as a single corporate representative is put forward to be examined by each party. You don't get wide-ranging examination or deposition of a number of witnesses. And of course, when you're dealing with a single individual, in many cases, they're not aware of all the facts. It's often just not possible for them to know everything that's gone on. So what often happens is that after the first round of discovery or deposition, there are outstanding questions that need to be answered. They get answered in writing, and then that witness is brought back to be examined again on those answers that have been provided in writing. So you don't have depositions of many individuals, but what can happen is depositions a few times of a single individual. And then you go to trial. And a typical trademark trial is going to last, let's call it a week. It could be longer than a week, could be slightly less than a week, but it's typically a week. And you have fact witnesses who are going to give testimony before a judge. There are no jury trials in trademark cases in Canada, before a judge, together with survey testimony and possibly expert witnesses outside of the issue of surveys.
So as Mark started talking about, there is possibility to actually have expert evidence and survey evidence at trial in Canada. It's definitely not a requirement, and an adverse inference is not drawn by the federal court judges if one is not, or one or some are not submitted. However, survey evidence can be very useful, and we wanted to share this case that Mark and I handled a few years back together on, as it's instructive when survey evidence is done well and is very valuable. So in this case, we were representing Diageo, who owns the Captain Morgan brand and the trade dress and the bottles. And as you can see here, the different name on the product of the Admiral Nelson's, it doesn't mention Captain Morgan, doesn't mention a captain, so it's a different name. And despite this, and I'll just give you the example with regard to the statistics that we got, statistical significance, between 16 and 23% of rum consumers interviewed were confused. And we also got similar results, excellent results, for depreciation of the value of the goodwill. And my understanding, it's the first case in Canada that had a survey that provided successful depreciation of the value of the goodwill. And the judge gave a primary reason in the decision of the judge why he was persuaded by the evidence was the survey evidence that was filed. So that's really good. So like in other jurisdictions, obviously, survey evidence has to be reliable and it has to be valid. And those are requirements for acceptance of survey evidence. The judges are very, I would say, conscious of those Mohan requirements in Canada. But lawyers and I think litigants need to understand the nuances of surveys to take advantage of it in some cases that you do need that little hump to go over and really be convincing a judge that there is that confusion, or there is that mental association that I was talking about before with regards to depreciation of value and the damage that's caused to it.
Let me just jump in. Yeah, just picking up on that, I think survey evidence can be really powerful. It's not required in all cases, straightforward, easier to understand cases. It's typically not required. And surveys, they're expensive, and it can often become a battle of expert testimony. But notwithstanding that, if you get a good survey in a case that's otherwise tough, as Katerina said, it can definitely give you a significant advantage.
Yeah. So here, other reasons why the federal court and litigation, trademark litigation in Canada is, effective. And so Mark already talked about interim and interlocutory injunctions. I don't want to spend too much time on it because I'm conscious of the time. But, we do have the possibility of going for them. The same test in Canada, the serious question to be tried, irreparable harm and balance of inconvenience, is similar to what I think the test is in the US. Obviously, I'm not a US attorney. But where we differ in Canada, and I would say specifically in the Federal Court of Canada, where we're often before the court for these types of issues, is the court is rather insistent upon the need for evidence to establish irreparable harm. If not, usually the injunction is refused. And so it can be difficult. And those kinds of things. Anton Pillars is another form of a very effective, it's a civil search warrant that modifies the normal rules on discoveries and records and enables an applicant who files such a motion for an Anton Pillar to attend at the premises of the defendant without notice and take possession of certain documents or make copies of documents. That's happened as well. It's available and tightly sort of monitored and regulated by the courts, and oftentimes having the need for an independent counsel to be hired by the applicant to go there and check to see that it's being done, correctly, according to the draft, the order actually that was rendered by the court. But so it's important that it's only available, Anton Pillars, when the need for preservation of the evidence is required and it's showing a real risk that the evidence will be destroyed. So that's important. And it also requires obviously a strong prima facie case of infringement or passing off or whatever other ground of case. As for summary trials and summary judgments, it's another mechanism available to brand owners who is to expeditiously dispose of a matter before the court. It's available upon filing of a motion, and it could be requested on one or all of the issues raised in the party's pleading. It's only available after the defense has been filed by the other side and before a trial has been set down. The Supreme Court have said that if a summary judgment, it has to be interpreted broadly, and if the court is satisfied that there's no genuine issue for trial and it can be decided on the summary judgment, it should grant summary judgment. And summary trials, while they're mini trials, the standard of proof is the same in a summary trial as a regular trial. However, the paper record that you use consists of, affidavits, the admissions that you would have extracted from requests to admit, affidavits, statements of experts, etc., and discovery read-ins. And it usually cuts down the trial, as Mark said, from, let's say, a week, and sometimes it's a week and a half or 2 weeks, quite frankly, in the last trademark infringement case that I was involved in between two big competitors. Obviously, there was a lot of, and there was like multiple survey experts and expert reports back and forth, so it made it complicated. But here, you can get it within 1 or 2 days. You have a summary trial 1 or 2 days at significantly less cost. Really
Katerina,
quick.
can I just say one thing just in terms of pretrial injunctive relief, which is just going back to the difficulty in the federal court. If you've got a counterfeit case, it's not a problem. Frankly, you can get pretrial injunctive relief in a counterfeit case. The court is prepared to and will be persuaded that there is irreparable harm in a counterfeit type situation. And the three elements that need to be proven, they're not watertight compartments. So if you have an extremely strong case on the merits, typically you need less in terms of irreparable harm or the balance of convenience. In an infringement case that isn't counterfeit, and when you're dealing with a defendant who has financial means, that's when it becomes difficult, because the court has to be satisfied that the damages that you would receive at trial would not be enough, and that there would be some other form of harm that you would suffer that couldn't be compensated for at trial. And consequently, that often becomes a battle of financial experts in establishing whether there is irreparable harm.
Yeah, you're right. Here, another mechanism, Mark will talk a little bit more to streamline a matter before the federal court is the filing of an application. Instead of having it be a standard, the action that we call, starting by a statement of claim that Mark mentioned before, an application is a much more straightforward procedure whereby a brand owner can assert and enforce its rights against an infringer in a court proceeding based entirely on a paper record. Our Toronto office had an application filed, and it took them 6 to 9 months to go to trial for the Nintendo. And instead of costing the client a 1 to 2 week trial, it took 1 to 2 days instead. So very appreciated by clients. Of course, Mark will take you through,
Yeah. So, and again, in terms of the speed of an action, in contrast, typically, and it's subject to the court's availability. But, I think in the normal course, 2 to 3 years is typical to get to trial in Canada in an action in the federal court. There are exceptions. I had a case a couple of years ago that from the commencement of the proceeding to the first day of trial was only 10 months. And that was an over a 1 week trial. But that was quite extraordinary because a gap opened up in the federal court's schedule. Typically,
and you guys were willing to work really hard to make it happen.
Yes, we did. As for the proceeding by way of application, for those of you from the U.S., the procedure, frankly, is quite similar to that in a U.S. TTAB type proceeding. It's not done by way of live testimony at trial. It's not wide-ranging depositions. Instead, it's affidavits, cross-examinations on those affidavits, and then argument before the judge at the hearing based upon the affidavits and the cross-examination transcripts. So again, one thing to bear in mind, though, is that even though it is consequently much less expensive, you tend to do some front loading of costs because you need to prepare affidavit evidence at the outset. So overall, much cheaper. Fees being reduced by 50%, 75% is typical, even though, as I said, there's a bit of front loading of those costs when you proceed by way of an application. That said, proceeding by way of application, even though it's fast and even though it's cheap, is not always the best way to proceed. In fact, I would say the vast majority of cases still proceed in the traditional manner. You aren't going to get wide-ranging depositions or discoveries when you proceed by way of application. Also, if there is a persuasive story that you want told by particular witnesses to a judge at trial, you'll be missing out on that by way of an application. So typically an application, very inexpensive, much quicker, but it's going to be in a more straightforward, simple case in which the merits, I think, are quite clear.
So here, trial remedies, whether you proceed by way of a regular action, as we call it, or by an application, which was faster, the relief and remedies available to a successful litigant are the same. Benefits of being in the federal court is you get a nationwide injunction across Canada. And of course, the courts having an exclusive jurisdiction to expunge registrations is very important. Provincial courts cannot expunge trademark registrations. They could just make them not applicable inter partes. And so unlike in the US, talking about cost awards where attorneys' fees, my understanding is they generally are not recoverable unless they're specifically permitted by contract or a statute. In Canada, a successful litigant can recover typically between 25 and 33%, sometimes even a little bit higher, 40% of its incurred legal fees, and together with all the reasonable disbursements. So of course, expert fees, survey fees, etc. as well as its own damages that is suffered or an accounting of profits realized by the infringement as a result of the infringer's activities. So those are the kinds of remedies: of course, destruction and delivery up, if that's still existing after so many years of litigation, and damages or profits, I already said, plus interest. So unless you have any comments, Mark, the only
comment I was going to make, which is it's in the rare situation, but certainly if a court believes that the litigation was handled in an egregious way, then they may award solicitor-client costs, so essentially full indemnity, which is payment of all legal fees. But that's quite rare.
Rare, very rare. People sometimes ask for it. At least in the old days, they used to include it all the time in their pleadings, and now they just don't, unless they have real reasons for doing so. Here, really quick, another change that is in the books but hasn't yet occurred is the requirement to show use in infringement proceedings taken based on what I consider a young registration of less than 3 years. And it makes sense in the sense, I think it's a good amendment in the sense of those trademark applications that have been filed and yet there may not be use, and you need that requirement to show use in infringement proceedings. So I think that's really important. And that should be coming into effect probably next year.
You know, this really came in because of the concern about trolls obtaining registrations not based on use. We have lots of questions, though. We'll have to see how this shakes out. I mean, you can well imagine situations where a brand owner has a registration covering 3 different classes of goods. It has use on one class, and the alleged infringer has goods that are completely dissimilar, and the brand owner doesn't have use on those goods.
Yeah.
As of now, we don't know what's going to happen. So,
turning now to Mark, this is your slide.
Okay. Sure. So invalidity and non-use cancellation proceedings, beginning with invalidity proceedings in the federal court. This is a litigious process. This isn't the simple, straightforward non-use cancellation in the Trademarks office. The expungement proceeding, it can be brought in one of 2 ways. The most common way is when you are a defendant, you've been sued for trademark infringement or depreciation of goodwill, and you bring a counterclaim. You bring a counterclaim typically to expunge the plaintiff's trademark registration. The grounds for expungement, very similar to those in an opposition proceeding, including bad faith, descriptiveness, non-distinctiveness. One point, though, of course, on expungement is that once the trademark has passed the opposition stage and the mark is registered, there is then a presumption that the trademark is valid. So then you have a burden to overcome in the expungement proceedings that is likely a little more challenging than in an opposition proceeding. Katerina?
Here, Mark, did you want to talk a little bit about the recent case that I sent you in Beijing?
Sure.
Or no?
So just very quickly, because we are a little
Running a bit late.
challenged in time, but there is an interesting case from our federal court in relation to expungement of a registration on the basis of bad faith. It really is the first case in Canada in which a registration has been expunged on that basis. It's a situation in which someone in Canada had registered a mark, not just with knowledge of the foreign mark, so that's not enough, but rather it was clearly a situation where the individual had no intention to use the trademark, and he was essentially using it to extort the trademark owner. So
had filed other similar registrations for other trademarks. But it's good. We wanted to share it with you just because it is the first case in Canada that deals with the bad faith provision. So turning now to summary cancellation proceedings or non-use cancellation proceedings, very useful proceedings. It's similar to what's been introduced in the US. It's a simple proceeding that can be filed with a simple letter. You know, a letter, you pay the fee, the government fee with the Trademarks office, and you're just basically asking the office, please send a notice to the other side, to the registrant, you know, or the owner, asking them to substantiate their use. If the other side doesn't file their evidence, it basically falls. You know, is it deadwood? We'll talk about that after. But it can be filed anonymously, which is really cool in the sense. It could be filed even by a law firm, like our law firm. The requesting party doesn't need to do anything, quite frankly, other than there's no evidence to be filed other than the request and the letter. They could let it go, the proceeding, and just sit back and watch. Of course, many times we do more than that. We file, you know, written representations, written submissions to show that there's no use, for example, if that's the party that we're representing. So, and while there is no need to do due diligence before any investigations, before initiating, some investigation about opposing parties' non-use is always preferable to ensure that you're launching the Section 45 at the right time. Here, again, these proceedings are not intended to be full-blown contentious proceedings. It's the corollary way to the fact that it's a simple way of that the Section 45 is filed. There's a low threshold of evidence that is required. In other words, is the trademark deadwood or not? And so, for example, for goods, has there been the filing of evidence of a single sale of the good with the trademark marked either on the good or on the invoices in the normal course of trade in the last 3 years? That would suffice to withstand the summary cancellation proceeding, and the registration would be maintained. And here, because the evidence, is only filed by the registered owner, the requesting party cannot file evidence. And again, you cannot even cross-examine on their evidence. So the evidence of use has to be clear, that's filed by the registered owner. It has to be without ambiguities, because usually that'll be used against them. And where it sometimes gets more complex is where the trademark that is used is not identical to the registered trademark. And here we talk about, jurisprudence talks about whether there's an immaterial variation to the mark and whether the dominant elements have been maintained. Usually that's enough to maintain the registration of the trademark. But with the threshold being so low, the trademarks office is rather exacting on the requirement to prove use of the marks. You have to be careful. You can't take advantage of it. And just, don't take it seriously is what I'm trying to say. Mark, last slide.
Sure. So as Katerina's mentioned, Section 45 proceedings are intended to be summary in nature. They're very straightforward. And before we get into the nature of the process itself, it is not uncommon that a defendant in trademark infringement proceedings, if they want to adopt a scorched earth type of defense, want to obtain as much leverage as possible and apply as much pressure as possible to commence a whole whack of Section 45 proceedings against the plaintiff's trademark registration, because it is so simple to do. Once the Section 45 proceeding has been commenced, then the brand owner has the onus of filing affidavit evidence establishing use of the trademark in Canada during that proceeding 3-year period. They've got an initial 3-month period to do so, although they can obtain a 4-month time extension. As Katerina has said, consistent with this being a summary proceeding, there are no cross-examinations in the Trademarks Office on that affidavit, and the requesting party cannot file evidence in rebuttal or otherwise in connection with the issue of use. Once the evidence goes in, there's an opportunity for both sides to file a written argument and to attend an oral hearing. There's also an absolute right to appeal to the federal court. In terms of appealing to the federal court, unless there is new and material evidence that would have affected the board's decision, succeeding on an appeal is difficult. It generally requires that the board's decision wasn't reasonable, and that's very difficult to establish, or that there was an error that was overriding and culpable. Again, extremely difficult to establish. So while there is a low threshold in Section 45 proceedings, it's very important to get it right, because unless you have new and convincing evidence on appeal, you're unlikely to succeed on that appeal.
So we're finally at the question period. Mark, I'm starting to look at the questions while you were speaking. Maybe you can quickly answer, what are your thoughts about whether it's worthwhile to have your registered trademark recorded with customs?
Yeah, I mean, short answer is yes. It is an inexpensive and simple process to record with customs. Like in many countries, having your trademark registered with customs does not mean they will necessarily locate and find all counterfeit merchandise that's coming into Canada. However, certainly our experience has been very good with customs. We do get contacted quite frequently by customs. They alert us to infringing merchandise or merchandise that they believe may be infringing, and they ask us, what do we want to do? Are we going to commence a proceeding? If so, there's a simple and summary procedure for detention and dealing with the counterfeit merchandise.
I'll take another question that just came in. Our opposition and cancellation proceedings where loser pays costs. So just to be clear on that, currently in opposition proceedings or cancellation proceedings before the Trademarks Opposition Board, there are no costs currently, but it will change with the new amendments into the case. When opposition proceedings and or cancellation proceedings go on appeal to the federal court, there is an award of costs. So that is the answer to that question.
There was one question about thoughts about using non-survey expert witnesses at a trademark trial. So our Supreme Court 10, 15 years ago issued a decision that was quite critical of, in trademark cases, using survey experts other than for the purpose of expert witnesses, other than for the purpose of a survey. They essentially said, look, if this is a matter of common sense, that's our role as a judge to understand these things. We don't need expert testimony on this. That said, my own view is that if you get into a case that is very important, if you are able to locate an expert who's very good, who has been well prepared, and especially if it is a case involving goods or services that are a little bit unusual, that a judge wouldn't necessarily know the ins and outs of that industry, I think having an expert can be very worthwhile in that case.
Mark, I'll take the next one. Are punitive damages awards or treble damages available in Canada? So firstly, on punitive damages, they're rather uncommon in trademark litigation proceedings to be awarded only when the court feels that there's been some kind of egregious, behavior, something to be malicious, oppressive, the need to punish a party for that. And the amounts, my understanding of the punitive damages are more modest in Canada in any event. And as for the second part of the question was the treble damages in Canada for willful infringement are not available. We don't multiply it.
There's one, I don't know how much time we have, but there's a question asking what is the difference in oppositions between lack of distinctiveness and mere descriptiveness? There is a difference. Lack of distinctiveness in Canada can be one of two different things. One, that the trademark is not inherently distinctive in that it, for example, it's a one-letter trademark that might be considered to lack inherent distinctiveness. More typically, it would be lack of distinctiveness in fact in the marketplace whether it's through genericism or common adoption of those elements by third parties. So those would be the differences with the descriptiveness argument.
Well, listen, we're out of time. I just wanted to thank everyone for attending. I wanted to thank my co-speaker for working with me on this presentation. It was a lot of fun. Hope you guys enjoyed it as much as we did. Even though we can't see you all in person, we're wishing you all the best and take care.